Good afternoon. This is Scott Horton. I will be presenting today's webinar. We've just opened access for the attendees to log in, so we'll give you a couple minutes for everybody to get logged in, and then we will get started. Again, we are just waiting another minute or two to let everyone get logged in to the webinar, and then once we do, I will begin the presentation on the new hiring restrictions in New York. Okay, I'm just going to get started with a couple of preliminary comments. So you will all, if you're registered for this email, get access to the replay and the slides by tomorrow by email. So you can anticipate that. And there will be question and answer at the end. If you have questions, you can enter them with the question and answer feature. If you enter them in chat, that's okay too, but if you try to do it in the actual Q&A, that will be easier. I saw a comment about the echo. Hopefully that just fixed it. So a couple of people logging in, so I'm just gonna wait until we really get into the presentation, but I will be talking today about the new credit check ban that takes effect very soon from New York State. Okay, we will see if this fixed the echo. Thanks for pointing that out. Hopefully we are covered now. If not, it may be on your end. So again, there is a new statewide amendment to the Fair Credit Reporting Act in New York State, and that is primarily what we're going to be speaking of today. The The law that we're talking about, again, is a New York State law, so it applies with respect to applicants, employees in New York State, and that may apply to people who are outside of the state and employing people who work remotely within New York. The law does apply in both the public and private sector, so if you fit into any of those categories, then you are in the right place to get some important information that may affect your hiring practices in ways that you did not even anticipate. Okay, so why do I mention that? Because there are actually some aspects of the law that don't just pertain to credit checks per se. It does affect your background screening and your hiring workflows, as well as your vendor relationships to the extent that you do conduct formal background checks through outside vendors. And in those respects, you aren't necessarily going to start doing anything wrong. It's more likely that by continuing your existing practices and relationships, that those practices already have the risk built in because they may not be adjusted properly for the new legal requirements. The New York State law is clearly based on and in large measure copied from a New York City law from 2015. So if you have employees in New York City, then you've already been subject to similar restrictions. The New York City law will still apply, and to the extent it has any broader prohibitions or protections of employees or applicants, those would likely survive and not be trumped by any sort of lesser restriction from the New York State law. But for the most part, they're going to be the same requirements, with the exception of some possible nuanced aspects of the exceptions to the laws themselves, and more with respect to the procedural enforcement aspects of the laws. So generally speaking, what has changed? The New York State Fair Credit Reporting Act, which is a New York State complement to the Federal Fair Credit Reporting Act that applies nationwide, now broadly prohibits the use of consumer credit history for employment purposes. This includes things like hiring, or once people are already working, promotion and compensation decisions, as well as discipline and other terms and conditions of employment. The law labels violations unlawful discriminatory practices, but it's important to note the New York State law is not part of the New York State human rights law, which is the law that prohibits discrimination on other bases in New York, such as race, sex, age, and those types of things. So in interesting ways, the law references discrimination, and in fact even goes on to reference the New York State Division of Human Rights, but it's not part of the human rights law, and there's no direct jurisdiction by the New York State Division of Human Rights. So, why are we talking about this law right now? It was enacted in December of last year and now takes effect on April 18th. That's Saturday of this week as I'm presenting this live. From any of you that are seeing this after the fact, the law may have already taken effect. Why is it taking effect on a Saturday? It's just because it was 120 days after the enactment date in December. So that is when the law officially takes effect. If you're not already complying with the new requirements, then you certainly should be as soon as possible. And hopefully that means by Saturday. For many employers, it is going to require immediate process changes, not just policy updates. For the most part, you're not necessarily going to have employee-facing policies that need to be changed. You may, if you have something in your handbook, for example, that specifically says you do credit history checks on applicants or employees under particular circumstances, but more likely you're going to need to change some of your internal practices and procedures, and especially hiring protocols. So, what is prohibited? Generally, employers may not request or use for employment purposes something called consumer credit history. Consumer credit history is a new term that is defined now in the Fair Credit Reporting Act in New York State that didn't exist exactly before. Here's basically the definition of consumer credit history. An individual's credit worthiness, credit standing, credit capacity, or payment history as indicated by consumer credit reports, credit scores, or information the employer obtains directly from the applicant about credit accounts, bankruptcies, liens, and judgment. Applicant or employee if the person is already working when you're getting this information. It is important to note that this is technically not limited to background checks in the traditional sense. There is some potential confusion between consumer credit history and consumer credit reports that we'll try to explain a couple of times throughout this presentation. Again, if you obtain a credit report from a credit reporting agency, it generally may be referred to sometimes as a background check, then this provision could be implemented, but there are still consumer reports that you can get that would have, for example, certain criminal history that wouldn't constitute consumer credit history. Granted, there are other restrictions on using criminal history in hiring, but those haven't necessarily changed unless something arguably fits under the new category of consumer credit history. I'm just pointing it out that there are going to be some ambiguities, and not all of these issues have been carefully thought through or tested by the legislature before adopting the law, so there are definitely some gray areas. Generally speaking, while you can't ask about or use consumer credit history, there are some exceptions related to hiring and employment. There are certain legal and regulatory requirements that certain positions for certain employers do have to be subject to credit history type of background screening. That's relatively rare, but it does happen in some industries and in some particular jobs. There are some exceptions for law enforcement and certain security clearance positions. Peace officers, patrol officers, police officers, for example, may be subject to specific exceptions. There are particular financial authority-based exceptions. So you may have employees with uh, enough financial authority within your organization that you may have the right to inquire about and or use their credit history in hiring or other employment decisions. And there are some exceptions based on employees having access to sensitive systems or trade secrets. And we're going to go into each of these exceptions in some more detail, although, again, we're not going to be able to determine exactly when they apply and when they don't, because there remain some ambiguities. And of course, any good exception is a case-by-case analysis. Just keep in mind that the intent and the way the law would likely be interpreted is that most jobs will not qualify for an exception. So we're going to break this down into a few different categories as we go through the presentation now with that background generally in place. First, we want to take a look at financial roles within an organization. So just because you have an employee in some sort of finance related position in your company, such as accounting or payroll, someone who has access to financial data and maybe even the ability to make financial transactions, they're not necessarily going to be exempt from the restrictions of the new law. You're still going to have to meet specific statutory criteria for exceptions. As I said, this is going to require a role by role analysis. And by extension, that should mean that if you do find that a particular position is exempt or that an exception applies, you should document that exception and the basis for it. What are some of these relevant statutory conditions for related exceptions in this particular area? There is an exception if the employee is required to be bonded under state or federal law. There are certainly some government public sector positions where people are required to be bonded. Whether or not the bonding requires a credit history report is kind of irrelevant. The law says if they're required to be bonded, then they can be asked about their credit worthiness and the like, or you can obtain a credit history report on them. A separate exception would be where an employee has signatory authority over third-party funds or assets valued at $10,000 plus. The key condition here is third party. Um, and that means that you are talking about not the company's money, but some outside party's money. This is really going to try to address banking situations or other financial positions, not necessarily meaning that someone works in finance within the company as much as that someone works in the finance industry per se. However, there could be circumstances where your company does have access to third-party funds or assets, and they have the authority to sign off on those. For example, a law firm may have trust accounts for their clients where they have the authority to spend their clients' money held in trust, and that could exceed $10,000. So the people who have the authority to sign those checks would be accepted from the prohibition on credit history inquiries and reports. A separate but similar exception applies if the position involves fiduciary responsibility to the employer with the authority to enter financial agreements valued at $10,000 or more on the employer's behalf. So this is kind of the flip side in a sense to the third party funds, still the $10,000 level. These are going to be more applicable to some companies outside of the financial industry. There is, I believe, an expectation that this is a somewhat regular authority, not that just this one time this person was authorized to enter into an agreement that happened to be worth more than $10,000. So you would want to be looking at someone with general purchasing authority, for example, or could be a sales agreement as well. But it's not going to be your rank and file employee in most positions within the company. There are some other exceptions that we haven't really covered yet that warrant a little more detail. These are going to probably apply to relatively few of your organizations and in relatively few positions within your organizations, but they will be relevant to some of you. These are generally going to fall into the category of legally regulated positions. Some positions are subject to mandatory credit checks, such as the statute specifically notes the Security Exchange Act. For the most part, this is going to encompass a lot of banking and finance industry positions subject to the Financial Industry Regulatory Authority, or FINRA, disclosure and monitoring requirements. If you're in those industries, then you're probably well aware of heightened regulatory obligations, and generally speaking, you're going to be able to obtain the credit information you need about people subject to those requirements. If there are other state and or federal laws that require credit history to be evaluated in hiring or other employment decisions, then generally speaking, those are going to create exceptions. Where this is most likely to occur would be for a defense contractor with the US government and for government employees who may be subject, in either case, to security clearance requirements. So at both the state and federal levels, there may be government security clearance requirements, especially for federal contractors and especially in the defense industry. So where there are laws that require that those types of employees be subject to credit history checks, again, they're going to be accepted from the prohibitions of the New York law. There is a further complicated nuance in the legislation itself, referring to positions subject to a state agency background check, where the position is designated as having a high degree of public trust. For example, teachers in New York State are subject to mandatory background checks by the New York State Education Department. If those background checks were to include something that qualifies as a credit uh, history information under the new law, then arguably there would be a question as to whether teachers are in positions with a high degree of public trust. The very complicated thing about this is the New York State provision specifically references the commission as having the right to designate what positions have a high degree of public trust. There is no New York State commission that was clearly uh, referenced by using the term commission. The reference is just borrowed from the New York State law, where the reference was intentionally to the New York City Commission on Human Rights. So it's unlikely that state law is going to defer to the New York City Commission on Human Rights to set the scope of its exceptions. So I'm not exactly sure what's going to happen to clarify that. In New York City, the commission has indicated what it considers to be positions with a high degree of public trust, and it's generally commissioners within the city government or uh, attorneys, different council positions, and those people who report directly to city agency heads. So again, it's not really a clean fit translating from the New York City law to the state law for that particular exception. There are the exceptions based on certain security issues. There's two different exceptions listed that I've lumped together here. The first is one for employees with regular duties that allow them to modify digital security systems established to prevent the unauthorized use of the employer's or client's networks or database. I assume this means high-level IT personnel in some organizations. I don't know exactly who else it could refer to. I mean, if you have digital security personnel, uh, particularly, that's one thing. Many companies that would be employing people full-time at that level probably are already subject to other regulations and exemptions, but that one is there if you need it and it's applicable. And then there is one that's going to probably apply to more organizations, although it's less clear which people in those organizations, is an exception for employees in a non-clerical position having regular access to trade secrets, intelligence information, or national security information. The intelligence information and national security information provisions I don't think are particularly interesting here because those people are likely already subject to security clearance background checks, so another exception already applies. But regardless, to be clear, intelligence information here is talking about literal CIA level information, not necessarily the CIA, but we're talking about the you know, international or public interest intelligence, not just information about business intelligence within the typical company. But the trade secret provision certainly can apply to a private business. So then it becomes important to know what trade secrets include, which the statute does define, but it's also interesting that they've referred to non-clerical positions without further explanation. Um, I note on one hand that people who have access to trade secrets may obviously be clerical because they may be literally clerks or secretaries or people like that. So it's interesting that they're still not subject to an exception, even though they might genuinely have regular access to trade secrets. On the other hand, I assume production, manufacturing type of employees would be non-clerical. So presumably they could have access to trade secrets, and this would allow the exception to apply to them. I'm guessing that what was primarily intended would have been higher level engineers and executives, research and development types of employees. But again, the statute says what it says. As regarding trade secrets itself, it says that trade secrets are information that derives independent economic value from not being generally known by other persons, is the subject of reasonable efforts to maintain its secrecy, and can reasonably be said to be the end product of significant innovation. The statute goes on to say it does not include mere access to client, customer, or mailing lists. So if you have access to information about how to design a product that is patented, I presume that's not going to be a trade secret because the patent is public and anyone can figure out how to make that item. They just don't have the legal right to do it. On the other hand, if you know the secret formula to Coca-Cola, then that does derive independent value because other people don't know it, or at least that's arguably true. And then there's definitely security measures taken to maintain the secrecy. And obviously, there was some innovation to come up with the exact formula in that case. So it's going to be some actual business trade secret that's known only to limited people within your organization, with effort being made to maintain its secrecy, and just a client, customer, or mailing list is not going to be good enough. So there's going to be a lot of case by case interpretation here. I know most companies already aren't necessarily doing credit history checks on people just because they have access to trade secrets, but the exception is there if that is somehow relevant. Okay, now we're gonna circle back to background check reports generally. So before this amendment, the state, like the Federal Fair Credit Reporting Act, applied to consumer credit reports. And these are the laws that have been in place for decades now that require companies that are hiring and wanting background checks to give a written notice and get signed authorization from the applicant or employee to obtain the background check information about them from a third party vendor. Those requirements are still in place. So, to the extent that you can still obtain credit reports for some lawful purpose, you still have to satisfy those same types of legal requirements, including if you get criminal history information or credit history information that results in not hiring someone, then you have to give disclosure of that fact and follow certain procedures. And in New York, you have the additional restrictions on refusing to hire someone based on a previous criminal record. But there are circumstances where you could still get that information and make decisions not to hire or take other disciplinary or employment action based on what you obtain from a consumer credit report. So the change is that to the extent a consumer credit report bears on a consumer's credit worthiness, credit standing, credit capacity, or credit history, you are now prohibited from obtaining that from a credit reporting agency, a background check vendor, unless an exception applies. So that means if you are getting background checks through vendors and you still have legitimate reasons to do so, you either need to make sure you have an exception to get the credit history information, or you need to make sure that the vendor is not providing any such credit history information. Yes, New York law does now prohibit the vendors from giving this information. So it may be that they are asking you why you need it and whether you have an exception that applies, etc. But it is also possible that you're dealing with a credit reporting company that's not up to date on the New York requirements. And of course, if you are dealing with a company not based in New York and for whatever reason doesn't normally provide credit report to New York employers, you might have heightened risk in that regard. So again, it's hard to talk about all of these in order on separate slides. So I've already basically said this. The complicating fact between what might still be permissible out of a consumer report and what is prohibited isn't entirely clear. So the other aspects of consumer reports, besides the credit history, includes information bearing on the person's general reputation, personal characteristics, or mode of living. That could still be obtained um, following appropriate procedures and doing it at the right time in the hiring process. But there are some ambiguities. So if someone was convicted of some sort of fraud, does that arguably weigh on their credit worthiness? I'm assuming that that won't typically be something that would cause a problem as long as you're not asking for credit history and number of accounts and details of someone's um, bankruptcies and judgments. But there is some potential ambiguity in which areas are now prohibited in a consumer report and which areas are still fair game. Multi-state employers, as I mentioned earlier, I know some of you certainly have employees in multiple states. Some of you have employees primarily outside of New York State, but some people who either work in person or remotely in New York State. And these new requirements will apply to you with respect to those employees. Conversely, those of you where the majority of your employees are in New York State, you recognize that you may now be complying with these requirements in New York State that don't necessarily pertain elsewhere. What are some of the risks and challenges in this setting? First of all, there's the Federal Fair Credit Reporting Act, so you still have to comply with that, but don't merely apply the federal standards broadly where state laws have greater restrictions. The federal law does not presumptively trump the state law. Um, in most cases, you would have to apply the greater restrictions here of the New York state law. So, one way or the other, you should implement New York specific workflows and vendor instructions if you're going to distinguish how you handle this from state to state, especially if you normally work with one vendor in one particular state, and then you're crossing over to another state in either direction. Certainly, you could just choose not to seek credit history information, even in hiring someone outside of New York State, which would be fine. You just need to make sure that if you're going to do that, the vendor knows what information you want. The further hurdle there is you need to avoid violations with relocations and promotions. So what you're doing in one state may be perfectly fine, but if that person then applies for a promotion that will require them to move into New York State or New York City, where the city laws would also be applicable, then um, consider that you may need to not use credit history in that scenario. Likewise, someone that just happens to move, maybe works remotely and currently lives in Pennsylvania and happens to move to New York State and is now working in that state. If you've already hired them based on a credit history check in the past, just like if you hired someone in New York State before the law took effect, having conducted a credit history check, you should be fine. But if there is some further decision to be made regarding their employment once they're in New York State and once this law takes effect Saturday, you can't use that information again unless you can apply an exception. Applications and interviews. This becomes a important side note. Side note, not meaning that it's inconsequential. Side note, meaning it's different from what the Fair Credit Reporting Acts have done historically. So in the past, you could ask whatever you wanted without violating the Fair Credit Reporting Act. You were subject to other legal restrictions on when you could ask about and when you could use criminal record information, for example. But there's really nothing specifically stopping you in New York outside of New York City from asking about personal financial issues. You couldn't uh, be found necessarily to have discriminated on that basis alone. Now, just asking about someone's financial history, have you ever filed for bankruptcy, would violate the New York State Fair Credit Reporting Act. So that also means you need to remove questions like that from applications if you have it. Again, unless you know that an exception applies for the particular position. And of course, similar questions need to be avoided in interviews. So if you have any risk that someone doing an interview in the hiring process might have, for some reason, the idea of asking about someone's financial history, that needs to be uh, prohibited within your organization. Again, unless it's formally part of the process of obtaining some necessary clearance from the government or subject to FINRA or some other legal obligation. Where again, hopefully you've documented when and why the exceptions apply. Where the exceptions apply, you need to consider handling this consistently. You don't want to make inquiries of some applicants that you don't make for other applicants, even though you may be allowed to. Because the exception applies, you should still limit it to only seeking the information that you need out of risk that you could somehow be then discriminating on some other basis by, for example, only asking employees of a particular race about financial issues. There, again, whether the exception applies or not is not going to protect you from a violation of the New York State Human Rights Law or Title VII. Go back to the vendor issue. Ultimately, it's going to be the employer's obligation to not use or request consumer credit history information. So again, don't assume the background check provider will adhere to the legal restrictions. And even if they mean to, intend to, and are aware of them, there can be complicated situations where it falls through the cracks. Again, especially if you're dealing in multiple states, and with vendors that are used to providing certain information to your organization, but won't be able to for a particular position. So you should at least review your contracts and work orders and procedures in obtaining these credit reports, or really consumer report generally, if you're still going to get them for criminal history reasons, to make sure they're only going to include what you're allowed to obtain in any particular case. Ideally, confirm the actual report contents before using them in decision making. As long as you haven't asked the consumer reporting agency to provide you credit history information, if they inadvertently provide it to your organization, you haven't necessarily done anything wrong. But if you get it and say, well, we've got it now, we might as well use it, that becomes the problem. So preferably someone who's not making the hiring decision would screen the report obtained to make sure it doesn't include anything that it shouldn't. That might not be something you can do indefinitely, but might be something you want to increasingly adhere to in the short term based on the new law. Okay, we're doing good. We're going to hit some questions here shortly. I know a couple have been asked, and go ahead and enter any more that you have. A few more wrap up issues that I want to address, starting with the enforcement and penalties provisions. There are a couple of interesting components to this legislation. Well, there's some I've already mentioned, of course, but a couple of more. But ultimately, the penalties would be obtained by aggrieved applicants or employees through private lawsuits. There is not in the New York State law a direct provision to take a discrimination based on credit history claim to the New York State Division of Human Rights. If someone does file a lawsuit and wins, they could recover their actual damages, i.e., lost wages for not being hired, for example, and their legal costs and attorney's fees. They could also obtain punitive damages if they can prove willful violations. So in that sense, the penalties are similar to what they could get through human rights law discrimination claim, but don't necessarily specifically include compensatory damages for emotional distress. And get, again, unless they could show that that was an actual damage resulting from the violation. The New York State Division of Human Rights, as I said, doesn't have jurisdiction over these claims, but again, I think because this was borrowed from the New York City law, the New York State Division of Human Rights has been directed to request information from employers regarding exemption usage and report it to the legislature. It's not clear that there's a reporting requirement, and it's not clear entirely whether employers have to provide the information that the Division of Human Rights requests, nor is it clear how the Division of Human Rights may seek to request the information. But the idea was clearly for the division to collect information, get it to the legislature so the legislature could reevaluate down the road whether they have the right exceptions and exemptions in place, whether that means they would need to add more exceptions or that they feel that employees are being deemed exempt more often than they should be, I guess remains to be considered. Overall, the biggest employer risks here seem to be over relying on exceptions. As I just said, we know the legislature is worried about that because they asked the Division of Human Rights to look into it. Otherwise, using outdated templates, if you always click a button and it sends a certain request off to a consumer reporting agency, then they may send you information that you used to get without clarifying that it shouldn't include credit history information. This could also mean your job applications, which, often now, of course, means online um, hiring tools. But again, if it does ask anything that may directly relate to credit worthiness, then you should reevaluate that, including whether you do have a valid exception. Of course, not knowing what vendors provide would be a problem in the sense if the information goes straight to a hiring manager who may not be up to date on these changes without some review by HR or someone else who is versed in this new legal change, that could become a problem for the organization. Informal decision making is again going to mean maybe the people that are doing the hiring are getting some information one way or the other about someone's credit worthiness that they're then using in their hiring process, even though they're not supposed to. The organization didn't necessarily expect them to be doing that, etc. So you really should be providing guidance to your hiring personnel. And again, localizing your multi-state processes is going to be important for those of you who do operate and have employees in various states. Again, it's okay to use a uniform practice across your company as long as that process satisfies the most restrictive states. So if you don't want to consider credit history for any applicants in the United States, then that's going to help you satisfy New York state law, but it's not necessarily your obligation in other locations. But you're not going to be relieved of the prohibition in New York State merely because your company is headquartered somewhere else. So, wrapping up here, what should you be reviewing? Obviously, your application and hiring forms. If there's any risk they're asking for now prohibited information, check your background check policies, make sure that what you are asking for is what you actually want and need. You may have to implement some exception-based branches in your practices. So again, we don't ask for this unless an exception applies, whether you have policies that are employee facing that are this specific or just internal protocols. You want to review all of that. As I mentioned, different aspects of your relationship with background check vendors, your hiring workflows, again, that largely runs into the interview practices as well, especially if you don't rely on consumer reports, background checks. Again, the law is not limited just to the formal background check, but to also questions that are asked of the applicants themselves and your position classifications with respect to any potential exceptions that you need to rely on. The final thing before we get to the questions, key takeaways, this is broader than the credit check ban in the sense that it's not limited just to the formal background checks you obtain from third parties. It does apply to direct inquiries to the applicants as well. Most of your risk probably comes from continuing existing systems. If you start a new process going forward, you likely in dealing with a credit check vendor or establishing policies, you would comply with the new limitations, but doing things the way you've always been doing it after uh, the Saturday effective date could become problematic. Employers need to control the information flow. Again, the vendors have obligations, but they're not necessarily going to protect you if they get it wrong. So make sure only the proper information is used in hiring decisions. And that goes into the next point. And obviously, with the law taking effect in 2 days, if you're watching this live, or already in effect if you're watching this later, act now. Don't wait until suddenly you're being sued for violating the new law to decide to address it. So with that, I will answer questions. Let me check now to see what questions I have. So yes, there is a question. If the company is based in New York but has sites in other states, does it apply to applicants in other states? Um, Probably not, but there could be some gray area there as well. If the employee is working and lives entirely in Texas and never leaves Texas, the fact that you're hiring uh, them in from a company based in New York is probably not going to be sufficient to give that employee coverage. But if the employee is going to travel to New York occasionally or regularly, or certainly if you're talking about an employee who works at a physical location in Pennsylvania, but works from home and happens to live in New York City, um, or somewhere else in New York State, then you're going to probably want to err on the side of assuming that the law would cover them. see if I have any more questions that have come through. Don't see any right now. Again, I would not be surprised if we see some amendments to this statute, whether that's soon or down the road after the Division of Human Rights reports back on the exceptions. But as I noted, there are definitely some aspects of the law that just weren't thought out um, at the state level and meant one thing in New York City and don't really have a counterpart at the New York State level. The vendors this would apply to. So when I'm talking about vendors here, I'm talking about consumer reporting agencies, which is a special term under the Fair Credit Reporting Acts. And those are defined basically as entities that are in the business of compiling information about individuals to sell to other parties for making either credit decisions or employment decisions for the most part. So again, if you're obtaining a background check from a, a different company, then you're likely obtaining a consumer report from a consumer reporting agency. If you hire a private investigator to provide a report on an employee, there are potentially distinctions to be made. There's something called an investigative consumer report, but depending on how that person obtains that information, whether it's through public records or asking people questions, that vendor could be subject to these same types of restrictions. If you call up someone that the person used to work for and say, "What can you tell me about this person?" And they say, "Well, I know he had a couple of bankruptcies." Um, as long as you didn't ask them for that information and don't use that information, they are not a consumer reporting agency in that sense. So hopefully that kind of clarifies it. But vendors, for the most part, we're speaking specifically about consumer reporting agencies, which are the background check companies. Uh, the, there are some gray areas there too. If you're using a staffing agency and they provide you information about applicants, they're arguably the consumer reporting agency. But for the most part, you just don't want to get any credit history information about any applicants, unless you know an exception applies. Because if you do, there's a risk you could be in violation either for asking for it or even if you didn't ask for it, using it. I don't see any other questions on my end yet. I'm happy to hang on another minute or two to see if there are any. But again, those of you who have stayed to this point, thank you for tuning in, and you will get a copy to the slides and the recording, and you will also be notified of future webinars, which we're hoping to do pretty regularly at this point. So if you ever have a suggestion for what you'd like to hear in a future webinar presentation on labor and employment law, especially in New York State, please let me know. Okay, not seeing any more questions coming in. I'm going to sign off. Thanks everyone for attending, and we will see you next time.